This podcast is brought to you by Ridout Maybee LLP, Canada's intellectual property and technology law firm. I am Colin Climie. I am a patent agent in the Ridout Maybee High-Tech Patent Practice Group. Some of the information in this podcast will refer to the Canadian Intellectual Property Office, which is responsible for managing patents, trademarks, and other forms of intellectual property in Canada. You can visit the links on this slide to learn more about Ridout Maybee, about my areas of practice and expertise, and about the Canadian Intellectual Property Office. And now on to the topic at hand. Should my client file a patent application? This podcast is aimed at legal practitioners outside the field of intellectual property who need to advise their clients about whether or not to file a patent application, or business owners or managers who may be contemplating whether to file a patent application for a recently developed innovation. At its core, a patent is a deal struck between an inventor and a government of a country. In return for disclosing an invention to be published by the government of the country, the inventor receives exclusive rights to make, use, and sell the invention. The term is limited to 20 years from the date on which the application is filed. It is also notable that the exclusive rights received by the inventor are transferable. That is, these rights may be assigned to another party. The topic that is the focus of this document is what is often called a utility patent. A utility patent protects the function of an invention, that is, how the invention works. There is also such a thing as a design patent, which protects the unique appearance of an object. Filing a patent application helps your client by establishing the client as the first inventor of the subject matter of the patent application. There were times in the history of innovation when being the first one to invent something was more important than being the first one to file an application for a patent. This led to complex schemes such as those where an inventor might commit an invention to a pen and paper document and send the paper via registered mail to himself. Most places in the world now recognize the first one to file an application for a patent as the first inventor. This has made it easier to determine rights to an invention. By having patent application on file before disclosing the invention to potential investors or potential licensees, an inventor protects against the theft of the invention by those to whom the inventor discloses the invention. Even before being allowed by the Patent Office, a patent application may be considered to be an asset due to the possibility of rights being conferred based on just the application. Section 2 of the Canadian Patent Act defines an invention as any new or useful art, process, machine, manufacture, or composition of matter, or any new and useful improvement in any art, process, machine, manufacture, or composition of matter. Notably, Section 27(8) of the Patent Act provides no patent shall be granted for any mere scientific principle or abstract theorem. The Supreme Court of Canada has ruled that higher life forms are not compositions of matter. Examples of patentable subject matter include a door lock, a chemical composition used in lubricants for door locks, a machine for making door locks, a method for making door locks, an improvement on any of these examples. Examples of non-patentable subject matter include natural phenomena, no matter how such phenomena is discovered, mathematical models, higher life forms, and methods of medical treatment. Patent offices worldwide have been struggling to define what is patentable subject matter for computer-related innovation. It is increasingly clear that something that may be done by pencil and paper by a human does not become patentable simply through implementation on a computer. The world of diagnostic applications is split into two categories, a data acquisition category and a data analysis category. Using a problem-solution approach, the examiner of a patent claim may determine a category into which the patent claim fits. If the claim fits into the data acquisition category, the claim is likely patentable subject matter. If, however, the examiner determines that the claim fits into the data analysis category, the claim is likely to be found to be non-statutory. For an invention to be patentable, the invention must be new, non-obvious, and industrially applicable. New, in part, means the invention is not described in a printed publication anywhere in the world. An examiner may make an obviousness rejection by combining two or more references to illustrate that a person of ordinary skill in the art could have come up with the claimed invention without exercising any inventiveness. The third of these criteria is typically easy to meet. A claimed invention is not new if every element of the claimed invention may be found in a single document. A claimed invention may be deemed obvious by an examiner if each element of the claimed invention may be found in documents that predate the patent application. One example of an invention that may be rejected for lacking industrial applicability is a perpetual motion machine. One aspect of a patent application is a full description of the invention. When describing an invention in a patent application, it is recommended to follow best practices by describing how to make the invention and how to use the invention. It is a requirement that the level of detail be such that a person having ordinary skill in the area of technology to which the invention pertains can, based on the patent application, make and use the invention without undue experimentation. Those experienced with drafting patent applications will know how much detail is needed for a patent application to be seen as having a sufficiently detailed description. The several hundred-year history of patents can be distilled down to a desire on the part of various governments to promote investment in research and also to encourage sharing of information that is obtained through that research. We have already discussed that a patent application may be considered to be an asset. It is worth noting that licensing of a patent or a patent application can provide sufficient income to offset those costs associated with obtaining a patent. An applicant associated with a patent application may be approached with a licensing opportunity based on a potential licensor reviewing a published version of the patent application. Patent applications are typically published by the patent office that receives the application. Such publication of patent applications comes about 18 months after a patent application is filed. So that's it for the Ridout Maybee podcast, Should My Client File a Patent Application? If you have any questions about the contents of this podcast, please reach out to me, Colin Climie, by phone or by email.